If you're a property developer looking at purchasing land or a redevelopment opportunity, it can take some time to conduct all the necessary background research and obtain a development approval. If you want to secure the property and ensure it isn't purchased by anyone else, but you don't want to lock yourself into the purchase and risk losing the money if you can't get the necessary approvals in time. Similarly, if you are selling a property and you expect to make a large capital gain on the sale, you might want to lock the buyer in and find a way to defer the capital gain on the whole amount rather than just the option fee to that later future date. When these situations arise, the most common way to secure the sale or the purchase of the property is to use land option contracts. When it comes to land transactions, options are more complex than regular sale of land contracts because the legislation is far more rigid and unforgiving. Given the complexities involved, it is imperative that you have an experienced property law lawyer assisting you with your option paperwork. At Maclarens, we have significant experience working with clients on a wide variety of land option contracts and can look after your best interests while we walk through the process with you and ensure the transaction runs as smoothly as possible. So what is an option? Land option contracts are agreements in which a landowner agrees to sell property at a stipulated exercise price to a potential buyer, usually a developer, within a specified period of time. An option agreement grants one party the right, but not the obligation, to compel the other party to enter into a sale of land contract. Under a property option agreement, the vendor and buyer agree to the sale price. The vendor receives an option fee, and if exercised, then the contract comes into play and the buyer pays the full price at the end of the contract. Importantly, if the option is not exercised within the specified option period, then the option lapses and the parties are freed from their obligations. A call option gives the purchaser the right to compel the owner of the land to enter into the sale contract for the predetermined price. A put option, conversely, gives the owner of the land the right to compel the buyer to purchase the property at the specified price in the future. Sometimes a call option will be combined with a put option and be called a put and call option. A put and call option is ordinarily drafted so that the call option period is first, allowing the buyer an opportunity to call upon the sale of the land contract, while the put option period goes second, allowing the owner of the land to call upon the contract of the sale of land if the buyer had not already enacted the contract of sale of land. Put and call options are commonly used for long-term transactions and can be particularly beneficial for tax and stamp duty reasons. An experienced property lawyer will be able to assist you and provide advice regarding potential benefits of a put and call option and how best to proceed. So what are some of the risks with drafting option agreements? With a standard contract of sale of land, if a vendor makes an error in the contract and does not, for example, include one of the prescribed documents as required by the conveyancing sale of land regulation, it is the buyer who has a limited right of rescission. In 2016, the Supreme Court carefully analysed the legislation regarding options and concluded that a vendor could rescind the contract if the paperwork was not compliant, even though the vendor was the one who prepared the defective paperwork. For example, a residential sale of land option must not be able to be exercised within the first 42 days of the option. If the documents fail to recognise this, the documents will be defective and either party can pull out. Similarly, if the prescribed documents are not attached, then either party has the rescission rights rather than just the buyer having the rescission rights. More recently, in 2021, the Supreme Court once again analysed the potential pitfalls with option agreements. At this time, the Supreme Court looked at the legislation and determined that Section 66 ZF certificates waiving the cooling off period in the call option did not waive the cooling off period in the put option. The consequences of this were horrendous, as a purchaser was able to pull out of 13 separate contracts on the basis that they had only given a Section 66 ZF certificate and not a 66W certificate as well, meaning that they did have a cooling off period in the put option. As you can see, land options are very complex areas of law. These transactions often relate to large-scale property developments and can involve many millions of dollars. It can also take up many years of everyone's lives. Put and call options are an important tool for a property developer or an option to sell. Ensuring your put and call agreement is properly drafted will make a big impact on just how effective it is at protecting your needs. This is also what separates a good property development lawyer from an average property development lawyer. If you are a developer looking to secure the property in advance, or you are a vendor and you've been approached by a developer to sell your property, you need to make sure that you speak to an experienced property lawyer about the option you wish to enter. Contact the experienced team at Maclarens Lawyers for more information.